Paul. Appreciate it. I appreciate the opportunity to be here, first of all. Thank you. And I know some of y'all have heard me speak before, and you know kind of how I am. I'm a little bit informal, just to make it easy. It is a lecture format, of course, but thank you, Paul. Thank you, Chamber of Commerce, for having me here. I will say, while you've got that particular slide up on the PowerPoint, if you want a copy of the PowerPoint, I don't have any problem emailing them to you, but just email me and say, hey, I was at the chamber, send me the PowerPoint slides, and I'll PDF it and send it to you that way. It gets into, with the cyber gremlins out there, we have to be kind of careful about how we disseminate that kind of information, because it's not legal advice, and you guys know that, but so we have to be kind of careful. But just email me. I won't send you a bill. I won't cry. I won't harass you. And you won't see unsolicited, hey, well, I want to follow up again. I love those emails where you think, oh, I know this person. No, you don't. It's spam. I'm not going to spam you. But I do need to have some control over the dissemination of the PowerPoint. But y'all go ask questions if you want to. We're going to take a break. I talked with Paul. We're going to take a little bit of a break after the first hour presentation, and before I get into the second part, which is going to be a little bit shorter. There's a lot to cover. I'm not going to read these slides to you. I'm not one of these people that sits there and read the slides that's in front of you, and some people like that and some people don't. But I'm trying to hit the high points. Paul and I were talking earlier about how there's a lot going on. There's a lot that's concerning. There's a lot that's humorous. There's a lot that's head-scratching in the news today, certainly with the transition. Anytime you see a transition, you have that. I try to look at what I think human resources, supervisors, business leaders, what y'all need to leave here knowing a little bit more about, rather than necessarily what was on the news this morning. That can impact employers, no question about that. Let me see if I can get this. I'm technologically challenged, I admit it, on the front end. I love technology. I have a love-hate relationship with it. So let's see, our firm, blah, blah, blah. I've just kind of talked to you about it. I will tell you that if you're not on our newsletter mailing list, add that if you want to be on it, and that way periodically when we send out a newsletter with an alert or something like that, that is not something that we pay for. It's not marketed by some company out of someplace. It is us. It is me or my partner Jerry Penn or one of the attorneys there actually writes the briefly when we feel like it's something that you need to know ASAP, and that can be helpful. We do a plethora of things that deal with employment, anything that really deals with the employment relationship, whether it's FMLA, alternative dispute resolution, OSHA, TOSHA, that sort of thing. We have those are all things that we do. We can also do employee training. I do a lot of going into facilities and actually meeting with your supervisors. Sometimes it's even with the employees, the hourly workers, depending on the company and what you need done. And I will just say, we'll talk a little bit about this later on. The EEOC is really looking at what is effective training. I'm getting ahead of myself, but one of the things that I'll refer to here is what I look at that really impacts business and employers generally is going to be something either coming out of Washington, D.C. from Congress, as in a law, or something coming out of a person with a black robe, the courts. The Sixth Circuit Court of Appeals is in Cincinnati. You'll see some cases where I refer to the Sixth Circuit. That's the Sixth Circuit Court of Appeals. If an employee gets mad and they want to file a federal court lawsuit against you, and we're here in Maryville, if they want to file a lawsuit against you, they're probably going to go to Knoxville federal court down the street from me, or they're going to get on the internet. Of course, it's all electronic. Point is, they'll file in federal court here in Knoxville. They might, depending on where they live, they might go to Greenville. You have Greenville, you have Knoxville. Then y'all have all the other state courts. The state court, of course, if you look at Nashville, Tennessee Supreme Court can make decisions. But if somebody goes to the federal court in Knoxville and they are not happy with the outcome, they appeal it. And they appeal to Cincinnati, which is Sixth Circuit Court of Appeals. If you don't like what the Sixth Circuit Court of Appeals does, you can ask the U.S. Supreme Court, and they can take your case or not. So that's kind of the line, and I like to tell people that because, you know, that's where I look for really the decisions that impact employers. There may be a Fifth Circuit Court of Appeals case that's interesting, or a Ninth Circuit Court of Appeals that keeps you awake at night, but we're not in the Ninth Circuit. And so unless it's a weird sort of decision, I'm generally going to focus on the Sixth Circuit Court of Appeals. So you may hear about, well, I heard the Fourth Circuit Court of Appeals. Well, okay, that may be interesting, but that's not really what I'm going to be looking at. Now, to get to the point, not get off on tangents, obviously when you have a change in administration, one that's so distinctive as this one from our previous administration, one of the questions is, what's in store? Oh my gosh, you know, the sky's falling, what's going to happen? I'm old enough that I can tell you that the pendulum swings, and it's going to swing, and I don't, you know, what you hope for as a citizen, we're all, you know, kind of in the same boat there, what you hope for is some moderation and sanity at some point. You know, it swings hard left, it swings hard right. What you hope for is eventually you get that delta right there in the middle. And I don't get all that excited about some of the extremes either way. It is, yeah, you do need to think about it. It can impact employers on a day-to-day basis, I get that. But in terms of a presentation of what you need to know as you walk out the door, I'm not going to really deal with a lot of the what I call sexier kind of topics. I'll address them, but there are some things that I think are more humdrum that employers need to be aware, that need to really remember. There are some things that change. Immigration and enforcement, yep, that's something that you need to think about. Federal agency focus, the EEOC regulations, who's at the head of the NLRB, who's at the head of the EEOC. Those are all things that are very interesting. Do we have a quorum at the EEOC? Well, give me a cup of coffee and I'll go sit down and talk with you for about an hour about whether or not we have a quorum at the EEOC. Does it impact you on a daily basis? Not really. There are a lot of compliance risks that remain for employers, and those are really what I am concerned about from what I want you guys to know. ADA enforcement, pregnancy accommodations, the risks of retaliation, which is in the second part of my presentation, terminations, the risk of artificial intelligence. Those to me are just as significant everyday problems that employers need to be aware of and need to take action to address. So I talked a little bit about what impacts employers. Obviously the Supreme Court impacts employers, the EEOC, and the thing about it is people will say, well, you don't have a quorum at the EEOC so they can't do anything. Well, that's really good, but why don't you go tell the investigator that just sent me an email earlier this week on a charge that's pending, and she wants like 2 pages of information. Well, you don't have a quorum. Yeah, I don't care. I'm still an EEOC investigator, and I can send out a request for information, and I'm aggressive. Because I've been at the EEOC for, I think she's been at the EEOC for 15 years. So that's my point, is don't get distracted with all the kind of stuff. You still got aggression with respect to these investigators, with respect to OSHA inspectors, although I will say TOSHA is significantly more reasonable these days for some reason. But you still have to watch them. You still have to follow them when they come in for an inspection. Don't just send them off into your plant. Take a picture. Whatever they take a picture of, you take a picture of. You'll be like white on rice with that OSHA inspector. Anyway, let's talk a little bit about executive orders, because I know it's on everybody's mind, and there are some executive orders that, yeah, you need to think about. But really, what is an executive order? An executive order doesn't really have a force of law unless it is based on an existing law. You still have to have the foundational law for the executive order basically to refer to. Again, we have a system that I happen to think works, checks and balances. I think that the process and how executive orders are treated is, to me, reflective of that. For example, okay, EO policy, EO 11246. If you've been in human resources for very long, you know EO 11246, affirmative action processes. If you've ever written an affirmative action plan, you know that when you put it on the shelf, or pull it off for an OFCCP investigation, but you know when you do that affirmative action plan, you feel like it's your firstborn. I know you've done them. You feel like it's your firstborn when you put all that information together and you gather all the residential information. It is a monstrous document. I'm not suggesting that you toss those. Executive Order 11246 has been there since I've been practicing law. It's like, and then Donald Trump rescinds it with Executive Order 14173. But it's only a partial rescission, only for race, color, sex, religion. Contractors had a 90-day grace period to transition, after which workforce balancing rather than affirmative action OFCCP type programs took place. But again, it's based on the law. The law on which 11246 was based is still there. You just don't have the executive order requiring you to develop those plans and the programs. But we're going to get another president in, what, 3 years? So is 11246 going to come back into existence? I don't know. Give me a crystal ball. My point is, don't throw those affirmative action plans out. That's a lot of work that somebody did. That's not to say ignore the fact that it's been rescinded, but don't throw those out. You still have to do your executive order with respect to the Vietnam Era Veterans Act and Section 503 of the Rehabilitation Act. Those are unaffected by the rescission of 11246. Those are still in place. So you still have to do those. What about EEO1s? You still must do your EEO1s. Despite the 11246 rescission, you still have to do your EEO1 reports. The time, of course, is closed for that. But you know, if you do EEO1 reports, the fact that 11246 was revoked does not change the fact that you still have to do the EEO1 reports. DEI, I'd rather not cover DEI because it's a worn out topic, but I would be remiss if I didn't cover it. Yes, he signed several executive orders to address diversity, equity, and inclusion. There are the executive orders if you want to read them. If you're like, I'd like to read them, but I don't know where to find them, shoot me an email. I'll send them to you, and I won't include a bill. It's kind of interesting to read. I'm not going to, again, because I've got so much to cover that I think is frankly a little more important, I'm going to kind of summarize my point on DEI on this last bullet. You need to shift, if you have a DEI program named as such, I would encourage you to get some legal advice about how to revise that. Because you do need to shift that program to something that is not DEI based with DEI goals, but it needs to be more inclusive, merit-based initiatives. You want to document your non-discriminatory practices. You really want to focus on merit and merit-based decision-making rather than someone's immutable characteristic, race, age, that sort of thing. There's also the Executive Order 14166, Defending Women from Gender Ideology. It directs federal agencies. Unless you're a federal agency, you could kind of do a little bit of pivot on this one if you're not a federal agency. But it does direct federal agencies to enforce laws based on sex-based rights, having male and female as biologically distinct policies. And really, there's also, let me finish here, there's also Executive Order 14168, redefining sex, defines sex as biological sex at birth rather than gender identity from federal regulations and guidance. The EEOC did rescind gender identity guidance, and that's significant. It rescinded part of some recent regulations that focused on gender identity. Agencies are supposed to use sex rather than gender, that sort of thing. So depending on where you fit in that executive order, how much of that impacts your workforce is really going to vary from company to company. Having practiced law in East Tennessee from Johnson City on down now here to Maryville, and all across the state, I can say, and being from Tennessee, I can say Tennessee isn't generally, there are exceptions, but Tennessee generally is not strongly affected by some of this guidance. As far as having a written DEI program, I would be hard pressed to say that any of my clients had a written DEI program. So I'm not sure how much of that, but just bear in mind that that is the way the pendulum is swinging. So if you've got those provisions in your policies, if you've got those plans in succession planning documents or things like that, be mindful of that. Be mindful that that's the direction that the federal agencies are looking. And so you may want to drop back and think about how you want to revise those policies or relook at those policies. Again, the idea is to make decisions on a non-discriminatory basis. And that's really what you want to focus on. But again, you as I said earlier, one of the things I look at is, as opposed to executive orders that are, issue another one tomorrow, issue another one next week. The Supreme Court, though, the executive orders have a legal tension with the Bostock versus Clayton County, which is the Supreme Court. That's the final word until Congress does something, which it hasn't. I'm not suggesting that it should, but the Supreme Court makes a decision, and if Congress doesn't like that decision, they can pass a new law. Until they do, you got the Supreme Court decision, and it protects transgender workers under Title VII. So they are protected. Transgender workers are protected. I do have some clients that have issues with bathroom facilities. Most of my clients will square peg round circle, they will get a single-use restroom, and they will designate it that way, rather than creating conflict with a transgender person wanting to use a bathroom that is different from their gender assigned at birth. But again, that can be something that you would want to handle with your legal counsel, because every employment situation is different. Be aware of the way the pendulum is swinging, but also be aware transgender workers are still protected. That's not a darn thing Donald Trump can do about that. You still have to deal with Bostock. Just be aware, you got to balance that. So I'm not suggesting that it's easy, but you've got to understand, the EEO is out there, the trend, the push, the newspapers, all that sort of thing. But you've still got Title VII. And Title VII protects regardless of gender identity. The EEOC, so what do? I thought this was a really good, and the EEOC, as much as I criticize them, they do produce some good things. Your tax dollars are at work, because a lot of times when the EEOC produces something, you and I paid for it with our tax dollars. So I do look to them a lot for what is their perspective. And this is the EEOC. These 4 bullet points are from the Equal Employment Opportunity Commission, which is a federal agency, in case you don't know. The EEOC is a federal government agency that enforces a lot of these federal employment laws. So Title VII, if a disgruntled employee wants to complain about discrimination, they will go file a charge of discrimination with the EEOC, and that's your first step before you can go into federal court down in Knoxville. Take no action motivated by an employee's protected characteristic. And it says, as you report data on employees' race, ethnicity, and sex, take the opportunity to remind your obligation under Title VII not to take any employment actions based on or motivated in whole or in part by an employee's race, sex, or other protected characteristics. That's basic, but it's good to hear it, and it kind of summarizes for me really what you need to take home from all the executive orders, the Supreme Court decisions. Like, oh God, what am I supposed to do? I'm reading these executive orders that are way over here on the right-hand side of the pendulum, but yet there are some court decisions, some other decisions that are over here on this pendulum. What do I do? Don't discriminate. It sounds easy. It's not. Take no action that are motivated by an employee's protected characteristic. Don't use employment demographic data. Don't compile that. You may need to compile it for your EEO-1, but you don't want to use that for your decision-making processes. Remember that Title VII's protections apply to all workers, regardless of race, sex, or another protected characteristic. And there is no diversity requirement. There is no diversity exception in Title VII's requirements. There's no requirement that I got to be diverse. There's no requirement in Title VII for that. The requirement in Title VII is that you don't discriminate. And so if you're looking at, we've got these numbers that we've got to fill. Well, you don't want to be like Novant Health. You don't want to wind up like this. After a week-long trial, a North Carolina jury found that Novant Health terminated David Duvall, who was a white employee. He was over the age of 40. He had been there, I believe he had been there for, I'm going to be conservative here, I think Duvall had been at Novant Health for longer than 5 years. I think he may even had been there longer. But he was replaced by a person who was not white and who was female. And he sued because he had no write-ups in his file. How many times have I heard, we want to fire Mary. Well, do you have any disciplinary actions? No, not a thing in her personnel file. Well, how long has she been there? 10 years. And there's nothing negative in her file? No, she's gotten raises every year. But boy, she's a horrible worker. I want to fire her. Yeah, and so it's like, let's talk. But in addition to finding liability, the jury awarded this guy $10 million in punitive damages. Now, what's interesting about the Novant Health case, because hey, I'm a Southern girl. I looked at it and I was like, well, North Carolina jury, they're going to appeal that one. No, you know who the foreperson was on this North Carolina jury that slammed Novant Health for their DEI? They determined that David Duvall was replaced as part of Novant Health's DEI program, which was in writing. And the person who replaced him was not as qualified on paper as David Duvall. The jury foreperson was a black female who was about 50 years old, who was the HR director at another healthcare company. And if you know anything about juries, you know the jury foreperson is that's the person you want to. If you're standing in front of a jury, you want to kind of try to figure out who's the foreperson here. They don't tell you that until after the verdict, but that's who the jury for. And there's an interview of her somewhere on YouTube or something where she said, "This is not DEI. This is not what DEI is about. What they did." So you don't want to be Novant Health, and that case. Of course, that's a 2021 decision, but that case is one of several where I think that's part of the pendulum swing that we're seeing is that sort of thing. More recently, Ames versus Ohio Department of Youth Services. This was a unanimous decision from the U.S. Supreme Court. Another example of why we're here, again, just issued in June. You probably heard about it, Ames versus Ohio. The plaintiff was a heterosexual woman. She sued the Ohio department after she was denied a promotion and she was demoted. Her previous position was filled by a gay man. She alleged that adverse employment action was taken because of her sexual orientation and the Ohio department's DEI program. Title VII, remember, Title VII makes it illegal for employers to discriminate against employees based on protected characteristics such as race, age, or religion, including sexual orientation. Now, what's huge about this case, not to get too much in the weeds here, but both the district court and the Sixth Circuit, the guys and gals at the Court of Appeals, both the district court and the Sixth Circuit basically dismissed her case and said, get out of court, Ames, you don't have a case. The reason was because for years, if you remember anything about reverse discrimination, you'll be familiar with the Bakke decision. Am I showing my age? How many people remember the Bakke decision? Nobody? Okay, I'm not going to tell you about the Bakke decision. It's B-A-K-A-E. It was one of the first decisions about reverse discrimination. It was California. And I don't remember how it came out, but this is the Bakke decision, and the cases after that, its progeny, held that in order to show reverse discrimination, you had to have background circumstances in addition to your prima facie case. Prima facie case is the basic elements of a discrimination case. Anybody who sues for discrimination, you've got to prove your prima facie case. It's basic. But in order to do a reverse discrimination case, if you're not in a protected group, like a white person or a heterosexual employee, if you're not in part of that targeted group that's supposed to be protected, you've got an additional element that you've got to prove. And if you don't prove those background circumstances, your case is dismissed. That's been the law since Bakke, really. Not anymore. Supreme Court decided, you can't make Ms. Ames produce more than what somebody else has to produce. Title VII applies uniformly. And in a really interesting turn, it was a unanimous decision from the Supreme Court. Have you heard of that recently? I think we've had 2 in the last year. Ketanji Brown Jackson wrote the opinion. Extremely interesting, well written. She hit the nail on the head. Very, very interesting. Good. I mean, she doesn't care what I think. Very good, well written. I mean, it was a beautiful decision. The statute prohibits intentional discrimination against any individual because of a protected characteristic, regardless of whether that person is a member of a majority or minority employee. So what does that mean for HR and employers? That means it's easier for everybody to make a case. So when a white person comes in your office, or when a heterosexual person comes in your office, or somebody that you don't immediately think of as being in a protected category, they're on the same playing field. Title VII does not distinguish between majority and minority status when evaluating allegations of intentional discrimination. So that's what you want to take from it, is everybody is on a level playing field. And if somebody thinks they're being mistreated as part of a DEI push, or you're giving preferential treatment to me based on not being in this category, you can't dismiss it. 5 years ago, 3 years ago, I'm not suggesting you would have dismissed it, but I'm suggesting you don't necessarily think, oh, they're going to go out and win a big judgment against me. Well, now they might be able to. So, I mean, it really is the way it always should have been, in my humble opinion. But I mean, you do read Justice Brown's decision, and it's sort of like, I mean, not to sound like a juvenile, but I kind of read some of the stuff in her opinion, like, well, duh. That's what Title VII says. Why is it taking us 20 years to get there? But anyway, so the law sometimes takes a long time. So, strategies. If you're a federal contractor and you haven't addressed any DEI or AAP issues, if you're a federal contractor, you really need to do that. Focus on veterans, disability, AAPs, and Title VII compliant. Make sure that is based on Title VII verbiage and not necessarily DEI verbiage. And if you've got a lot of DEI verbiage, terminology, that sort of thing, review those policies to really focus on fairness, compliance, anti-discrimination processes rather than DEI terminology. So that's the DEI part of it, and recent Supreme Court decision that deals with that, as well as an example of a case where you don't want to wind up with the Novant decision. Those are all, again, if you Google them, you'll have a lot to read. They're all out there. I-9, now I will be the first to tell you I am not an immigration attorney, but I know where to find one. And half of having knowledge is knowing where to find it. I have a partner, Jeremy Jennings, and he does nothing but immigration. And if you have an immigration issue, I would highly recommend getting in touch with him or whoever your favorite immigration attorney is. But because it is so, it is its own animal, and it can really create significant problems to have ICE in your cornflakes every morning, or the Department of Labor in your cornflakes every morning. I would encourage you to have an immigration attorney, at least that you're comfortable with, if you have a lot of non-citizen visa programs and that sort of thing. So again, there are a lot of temporary visa programs that are ending. There is certainly stricter scrutiny and use of enforcement. Be aware, just FYI, there is the alien registration requirement that went into effect, basically requiring everybody, foreign nationals 14 years of age or older who have not already been fingerprinted to register, and they have to do that. Again, that's not really an employment issue, but it's part of the it's part of the trend, it's part of the push, it's part of the aggression that we're seeing. And obviously there are problems if the person doesn't register. So that's something just to be aware of. Their end of categorical humanitarian parole programs. Humanitarian parole programs ended. The list of some of the countries that are impacted by that. They all have different dates, and as I say, I don't do immigration as a specialty. I do sometimes when a client needs it, I can delve into it. But I find that a lot of the information that you need on these dates and compliance and which country is no longer, which country is going to have a cutoff, where the temporary protected status is basically at the USCIS website. They update that daily, and you can see the exact date of when the TPS program is going to end for a certain country, and it's changing frequently. So if you have that, I suggest having that in your favorites that you go to if you have individuals who are worried about the TPS status ending and when do how long do I have, that sort of thing. And again, I do know that if an employee is looking at a date, an expiry date, my understanding is that if they haven't started the process of getting some other way of staying in the United States, they are already behind the 8 ball. What I will tell employers is be very careful about giving them legal advice, because this is a moving target, because it is very, very complex. You do want to be careful about helping them look up something on the internet and trying to give them advice about what they need to do. They need to get their own attorney. Because again, you don't want to be in a situation where, well, the human resources person told me X, Y, Z, and so I didn't do anything. ICE I-9 audits, notice of inspection is generally served on an employer. They're usually given a real short period of time to produce the I-9 forms. They can conduct an inspection of your I-9 forms. If procedural violations are found with your I-9 forms, you need to keep those. You have 10 business days to make corrections, and then they can assess it. You basically want to be on top of things with your I-9 forms. You want to be on top of things with your compliance. If you've got a heavy non-citizen workforce, my recommendations to you would be to have a plan, have a lawyer already in place. That, again, I'm not selling myself, because I would tell you it's not going to be me. It might be Jeremy Jennings, my partner, but it might be somebody else that you want to get. But have a lawyer who knows your company. Have a lawyer that you can basically put on speed dial and say, ICE is here, I need you. You want to have a plan. You want to prepare your front office. And I will, as an aside, I will suggest that your front office, whoever gets the people walking, if you have a reception, a lot of companies don't, but if you have that, whether it's TOSHA showing up, or the Department of Labor showing up, or IRS showing up, or ICE showing up, you want to educate whoever gets that front door, whoever handles that incoming call, whoever handles that introduction. You want them to know who they need to call, because 9 times out of 10, you don't want them handling it. There are exceptions. But you want to prepare that person to say, you need to call, here's, stick it right here in front of you, because they'll forget. If you tell them Monday, they might forget by Friday. But put it in front of them and say, this is what you do. If it's a government person, if it's somebody that you don't know, if somebody hands you something when they've got a badge on their chest and they hand you a piece of paper, that piece of paper needs to get to me. Because it's usually a summons or a complaint or an EEOC charge or something that management needs to know about. Use signage to demarcate non-public areas. Go with them. Use security cameras. Don't talk to them. Get your I-9s in order. Follow them. Make sure you take pictures of what they take. All that sort of thing. You want an exact mirror of whatever they get. If they are doing some sort of a raid on you. Again, first thing though is have your lawyer on speed dial. Yes, ma'am.
The use signage to demarcate non-public areas. Why is that important?
Because that way you can, if it's a non-public area, you can say that they have to have somebody with you. You can't go beyond this point without somebody from Wimberly and Lawson. We've got them all over our office. And so
like HR, that office would need to have that sign on it.
Yeah, okay. You need to, must be accompanied by a member of whatever, who's your company,
Yeah,
you must be only employees beyond this point or something like that. I mean, it doesn't have to be nasty,
right.
But it just
Keep
something
out,
so
right?
that you can, keep out, yes. Beware of dog,
right?
But yeah, it something to so that you can say, hey, we're not just making this up as we go along.
Right.
A couple of things that I'll mention about the big beautiful bill. I'm not going to get into the weeds on these because I could talk all day about some of these, but just so you know, there are some employment-related parts of the big beautiful bill that was passed. There are some increased fees with immigration. If you have sponsorships and that sort of thing, the fees go up significantly. If you have a dependent care flexible spending account, there's a change in the annual exclusion. There's a change in the 1099 reporting threshold for contractors. It's gone from $600 to $2,000. There are changes in your health savings account and what's allowed. There's telehealth that's going to be allowed as part of, that can be paid through a health savings account. And it also makes the employer-provided student loan repayment benefit permanent and indexes that annual limit for inflation. So again, if you have those programs, you need to look at the act and make sure you're aware of those changes. Let's see, W-2 reporting. Obviously, you've got some tip income that's going to be temporarily deductible as a deduction for individuals, but only in traditionally and customarily tipped industries. The deduction is limited to $25,000 of reported tips. If you have a company that deals with tips, traditionally and customarily, I really highly recommend you get with your CFO, your payroll, your CPA, whoever handles that, so that you are on top of how you need to report that, how you need to keep up with it, and how that's going to impact your payroll practices as well as your employees. Most of my clients, I do have some restaurant clients, which is really where I'm dealing with it, but unless you're in one of those, and the IRS is supposed to issue regulations here in the next month or so, I think, so as to what they consider traditionally and customarily tipped industries, but restaurants are going to be included, so that would be one. Overtime, employees will be eligible for a deduction for qualified overtime pay. Again, qualified overtime pay is a term that the IRS is going to define. I don't think they've defined it yet, but it gets very complex from a tax standpoint. If you're an employer and you deal with overtime, I would, that's something that you do need to get with your payroll people and delve into how that impacts your reporting. For individuals who get overtime, you're going to have to update processes to ensure that it's accurate and that it's something that they can use on their tax return. Previously enacted credit for paid family medical leave. If you do paid family medical leave, you know that it gets very complicated. They make it a permanent enacted credit. The credit's available for employers who offer paid family medical leave to their employees, and again, it gets kind of complicated. If you know you're doing it, you know that it's complicated. If you want to do paid medical leave, I would look into that aspect of the big beautiful bill because it impacts how you keep up and how much credit you get against those wages that are paid during the leave. So, with all that, I kind of have covered some changes. What hasn't changed? Well, E still equals MC squared. Newton's laws of motion have not changed. An object that rests will stay at rest unless it's put in motion. Laws prohibiting discrimination have not changed. Title VII, Civil Rights Act, Pregnancy Discrimination, Pump Act, you see them here. Just really quickly, Title VII, you know that it protects a number of categories. It hasn't changed. Title VII is still out there. And it's what has changed, everybody fits into a protected category pretty much. So there's going to be, if somebody feels they're being discriminated against or harassed or something like that, it's awfully easy for them to allege that it's on the basis of a protected characteristic. So you've got to think about the training, you've got to think about updating your policies, you've got to make sure that your policies are distributed, that how long has it been since you had an employee sign off on the handbook? Oh, they signed off on it in 2018. You probably need a new handbook. You probably need to get them to sign off on it again because they probably slept. Let's hope they've slept since they signed off on that handbook. And they probably couldn't find it at home if they needed it. So it's just making sure they understand this is the reporting, this is what our policies are, this is what you're supposed to do if you think you have a problem. Because again, what Wimberly and Lawson, what we like for you to do is to be a target out of range. And the way you get to be a target out of range is to handle these issues with employees internally. That's not to say you handle it like the Godfather, but that you have that opportunity to address it before it goes outside the family. Once a third party is involved, is everybody here from the government? Are you federal or state?
Local.
Local, okay, that's okay. Yeah. That's okay. I know I sound critical of the federal government, but I'm really not. I mean, it's my government, but depending on the person, they can be a pain, and be a thorn. And so and they're doing their job, but you don't really want it to go outside the family. Once it goes outside the business, once it goes into a third party, the EEOC, the IRS, or something like that, or a plaintiff's attorney, now you're dealing with somebody that you really got no control over. Not that you have control of the employee, but you have a say. You have obviously you have more of a say when it's right there in the palm of your hand. And that is so much better than giving a flippant response or an employee not knowing where to go, not knowing that human resources is the first step, and not having that rapport with employees are afraid of human resources a lot of times. And so you got to understand that you may have a policy that says, oh, you need to report it to human resources. And I had a situation with a client, not anybody in here, but probably 6 months ago, where an employee had a complaint about an issue. He had an unfair treatment issue, but he did not want to go to human resources, and he said, I don't want to go through all that investigation and all the stuff that human resources, I've seen you all put people through that, and I don't want to go through that. So he went to the EEOC. And so it's like, okay, one of the things I talked with my client about was, we need to kind of get a sense of why this person didn't want to come to you, not that individual, because it wasn't that person, but it was just the whole human resources office. So that's something that I think that hasn't changed. The ADA, military status, genetic information, pregnancy non-discrimination. A big deal right now is workplace accommodations. That is a big deal. Look at the laws that require accommodations. ADA, Pregnant Worker Fairness Act, the Pump Act, Title VII requires accommodation for religious beliefs, and of course the FMLA. And there's Groff versus DeJoy, another Supreme Court case that I will talk about very briefly, but it was a watershed decision because it changed the analysis for religious discrimination. He was a mail carrier for the U.S. Postal Service. He did not want to work on Sundays. Long story short, the Postal Service disciplined him and he eventually quit. That's really a Reader's Digest version because it was a lot. He even changed cities. Mr. Groff moved from one city in Pennsylvania to another city in Pennsylvania because he was trying to avoid working on a Sunday. And the Postal Service said, well, this is the area where you're going to have to work on Sunday. He said, oh, fine, I'll move over here. And he changed cities, picked up his family and changed cities to a place where they did not have Sunday delivery. And this case was during COVID, and what was the Postal Service competing with respect to delivering all that good stuff to our door during COVID? They were competing with Amazon. Amazon was delivering at 3 in the morning on Sunday. They never quit. Well, the Postal Service had to compete with them. And that was part of their rationale. Was, we got to compete with Amazon. And so they eventually told the place where he moved, the smaller town where he moved, they eventually said, yeah, you got to work on Sunday too. He eventually quit. The point of this is you've got to really be careful. Here we are getting ready to get in the ho-ho-ho season. So be careful about those religious accommodations. When I started practicing law back in the dark ages, you had to really prove a significant burden. For the plaintiff had to show a really significant problem. And the employer, all the employer had to show was just a little bit of inconvenience. And it basically you didn't have to accommodate the employee. I don't want to work Sundays. Oh, that's going to be a problem because Mary's going to have to work Sundays and we're going to have to pay Mary more. She's probably going to get into overtime. That would have been enough to say, no, you got to work Sundays or we can fire you. That has been the law. I've won cases for religious discrimination by saying a de minimis, just a slight inconvenience that the employer could articulate, and we would win the religious discrimination case. The Supreme Court changed that, and they said, no, why would de minimis apply in a religious discrimination case, but it doesn't apply in any other discrimination case? Again, go back to Catania Jackson Brown's decision in the Ames decision. Level playing field. Religious is level playing field. So if somebody comes to you wanting a religious accommodation, you've got to show a substantial burden before you can deny that request. And that's not easy. I'm not suggesting it's easy, because you do run into, how are we going to accommodate this? The decision, I think in this case, it was a unanimous decision. I can't remember who wrote the decision, but very rare. It may have been Justice Thomas. But anyway, in order to deny a religious accommodation request, you've got to show that you considered other options. Shift swapping, paying incentives, coordinating with other facilities to pull from a broader group of workers. And something that I've heard from court decisions over and over and over, a negative impact on morale is unlikely to be a substantial hardship. Coworker griping is not going to be an undue hardship. It's just not. And I've heard it so many times. Well, the supervisor tells me that he's going to have a mass exodus of employees if we allow this to happen. I'm sorry, but that's not going to be an undue hardship. It may be something that you need to address in a certain way, but it can't be the basis for denying the request.
Mary, just a quick question.
Yeah.
So that first employee that comes forward and says, I don't want to work on Sunday, and you say, okay, well, I'll be able to accommodate that. But then I have 6 more line up behind him or her and say, I need Sundays off too. Where's the...
I think you want to look at some of these alternative approaches. What I would say is, okay, are they basing that on religious? Mr. Groff was able to establish that he was going to church. He was actually, he had a sincerely held religious belief. I don't want to work on Sunday because I want to go watch the Nashville football team. That's not religious accommodation. You do have to be careful about how you define religion. Wiccan is religion. I learned that with somebody who filed a Wiccan based on a Wiccan religion years ago. But at the same time, anyway, there was a case where somebody asked for religious accommodation and didn't want to. The person wanted to leave work early, I think on Wednesdays, because he said he was going to go to church. And he wanted to leave at 3 o'clock to go to church service, and that was a religious accommodation. We could do it, and we allowed it, but then we got word that he wasn't going to church on Wednesday night. He was going elsewhere that was not a church, and we hired a private investigator and filmed him and confronted him and terminated him. So it needs to be a sincerely held religious belief. And if you have an influx of people saying, I don't want to work Sundays, I don't want to work Sundays, I don't want to work Sundays, the human resources needs to explain, and for example, Mr. Groff needs to be able to understand, hey, we're going to have everybody else on the shift do the same thing, so we're going to need to tell people that we're making this accommodation for you based on your religious belief. And the minute you do that, people are going to say, I heard Mr. Groff, cussing, or I saw Mr. Groff, doing something that's inconsistent with his religion. So you got to be prepared for that. But all these other people that are coming in, are they basing that request on religion, or is it just, I don't want to work Sundays? That'd be the first thing. Is it based on religion? What's it based on? The second thing I would think is, if it's a morale issue, then, are there some incentives that you can put into place? Can you say, hey, look, I get it, you don't want to work Sundays, we'll pay more for a Sunday shift. And so that's a cost, but if it's important enough to have the Sunday shift, then that would be kind of how I would look at it. What's prohibited, skip all down through there, but under the ADA, what's prohibited is not making reasonable accommodations to the known physical or mental limitations of an otherwise qualified individual due to undue hardship. That's really what is prohibited. There are some cases that illustrate that an employer's failure to grant a reasonable accommodation falls into a discrimination, failure to engage in the individualized inquiry. The root versus decorative paint, That was a reasonably recent case from the Sixth Circuit Court of Appeals. What happened there is Ms. Root worked for a paint company, and of course, working in a paint company, you're going to have paint fumes. And she had worked with the paint company for about, I think, 6 years, if memory serves me. And no problems, no disability, no complaint, no medical problems or anything like that. But Decorative Paint decided to redecorate, and they redid their entire facility. Once they redid their entire facility, she was working in a different location that was more affected by paint fumes. So she came in and said, I need an accommodation because of these paint fumes. The employer basically said, you've been working here for 5 or 6 years, however long it was, and basically said, no, we're not, we just went through this expensive redecorating, remodeling, everything like that, adjusting their business. And the Sixth Circuit Court of Appeals sent it back to the trial court and said, the employer failed to engage in the individualized inquiry. In other words, why the change? Slow down and ask, okay, she wasn't impacted by it for 6 years, now she's impacted by it. What's changed? Is there something? Yeah, her location has changed, and now she's closer to the fumes. So that was the problem there. Be sure there's an individualized inquiry. Now, if that doesn't make you lose sleep, then this case will make you lose sleep. This is the Yannick versus Kroger case. Employee returned from an extensive leave of absence. She was on a leave of absence for about 6 months, so serious health condition. And this is Kroger. This is Kroger like down the street. I love Kroger. But Kroger, my point in saying that is a sophisticated company. This is not a, your mom and pop grocery store. Sophisticated, great employer, union company. The case was out of Michigan, so it wasn't anybody around here. But she came back with no restrictions. Came back from her leave of absence. Yay, no restrictions. She worked in the floral department. Brings a whole new vision when I see the Kroger floral department. Anyway, when she came back to the floral department, her supervisor told her that the floral department looked scruffy or something. Didn't look up to snuff. Didn't look bright. She wasn't doing good. She was the manager of the floral department. She came back, and in these disciplinary conversations with her supervisor, the employee, this was about 2 weeks after she came back from work, with no restrictions, and she mentioned to her supervisor that she was struggling with getting back to the full-time schedule. Just having a hard time adjusting, getting back to the full-time schedule. Well, the supervisor wrote her up, gave her some counseling. The, flowers were still bad looking, so she demoted her. Long story short, Ms. Yannick eventually quit, and it was a constructive discharge situation because she felt like she was getting ready to get fired. I wish she probably was. And the district court dismissed the case and said, you never asked for an accommodation. You never requested that Kroger give you an accommodation. You came back with no restrictions. Sixth Circuit Court of Appeals, in its infinite wisdom, said, the supervisor, now you think about your worst supervisor out there, just for a minute. Okay, or your newest one, your greenest one. The Sixth Circuit Court of Appeals said, no, the supervisor should have inferred that the employee was asking for an accommodation when she said she was struggling. Would your supervisors infer that that's an accommodation request and start that process of accommodating? It's a scary case, but it shows me how important it is for, and again, nothing against Kroger's. I mean, it could be, you could replace the word Kroger with any company. I think it, again, it's how the Sixth Circuit got there was kind of circuitous, but it's there. It was an issue of fact, which means they sent it back for trial to the U.S. District Court. Yeah.
So at that point, when supervisor should have inferred, should Kroger have said, okay, we need some medical documentation, or we're gonna send you for fitness for duty, would that have been the right step?
What the court said was that she probably needed to be put like on a part-time schedule.
Without any medical documentation?
Yeah, she was released with no restrictions. And it's in the court, I mean, it's in the court record. It's not a HIPAA violation because it's, it's in the court record. But her leave of absence was for cancer. And it was, a lot of treatment and a lot of chemo, that sort of thing. She was gone for 6 months. And so I think the court was sensitive to that, as I think I would be as a litigator if you called me up and said employees just come back from leave of absence for 6 months for cancer. That's not the plaintiff you want. That's the reality of it is, and I think the court was sensitive to that. But no, I don't think it would have been a fitness for duty because, there was no mention of a fitness for duty. I would not, if they had called me up, Joy, I probably would have said, she didn't ask for an accommodation, but with this court case, I would say, sit down with Ms. Yannick and say, what can we do? What can we do? You've got no restrictions. What can we do to help you get back to the full-time schedule? And I think what I would suggest to an employer is, can we work her on a part-time basis for 30 days and get her to the point where she's no longer struggling with the full-time schedule? It's a bad case. I don't like the case. You had a question?
So as that worst supervisor, I've had employees, and I just want to make sure this might be the right thing to do, because I'm sure I've tortured Joy quite a bit. But they've come to me before with child care issues, and they've had some pretty substantial changes in their life recently that have reduced their access to child care. And they've said, I can't work Sundays for a little while because I have no one to watch my kid. At that point, I refer them to HR. Is that the most proper thing to do? Because I can't make that decision. Okay.
That's perfect.
Sweet.
Sorry, Joy.
Sorry, Joy.
And absolutely, that is what the supervisor should have done. And really, when I read the case, that's really what the supervisor should have done here. She was I won't say that, but she was a hard nose. She was a new supervisor. In between that 6 months, Ms. Yannick's supervisor, who had been her supervisor, changed, and this person was a new supervisor. And just intolerant of, I guess, drooping flowers or something. But that's exactly what this person should have done. That's why I say Kroger's is a sophisticated company. If the supervisor had referred it to the Kroger Human Resources Department, we wouldn't be talking about it because it's the Kroger's. I know Kroger's. They would have dealt with it, and it wouldn't have resulted in a demotion and a constructive discharge. And so I think that's the perfect answer for a supervisor is get it to Human Resources. And what I like to tell supervisors, if I do supervisory training, is when you are faced with that kind of a conflict, you have immediately a brick on your shoulder. Get that brick off your shoulder and send it to Human Resources and document that you sent it to Human Resources, because Human Resources will deal with it. Human Resources is trained in knowing where to skate too closely to the edge and interactive process, and that's the real deal, is they did not engage in the interactive process. Even if the employee request seems unreasonable, you should still engage in discussions with them before reaching any type of determination or decision. Hear them out. I think it's good to explain to the employee why a suggestion is not reasonable. We can't do that because, or why it creates undue hardship.
And the other thing, I always tell supervisors, bring it to me so we have consistency, because you think one thing, he thinks another thing, she thinks something else. and I can't have that inconsistency among the company.
Absolutely. Perfect point, Paul, because then that's where human resources really comes in, because you're going to know what you did last week to this facility, and you don't want to be inconsistent. Got a little bit about non-compete agreements. I don't want you to sleep too much on non-compete agreements because there is an FTC task force that has been set up, and it's the Chairman Ferguson of the STC has issued a task force, and you guys know, I hope that if you are in an HR group where you sit around talking about these things, you want to be very, very careful, because the FTC has said that that can have a that can create wage fixing agreements, poaching, that sort of thing, that can be a violation of federal law. So be careful about that. If you're shooting emails back and forth to your HR group, what are you all doing with raises this year? Oh, we're giving a such and such. You don't want to do that, because that's a violation of wage fixing agreements. AI, just real quickly, I usually have time to have fun with this, but I won't do that this time. There are cases, if you use AI in your hiring, there's a case that, just the case that I had up there, EEOC versus iTutor, a consent decree was entered in that case. The EEOC sued the employer, alleging that the software automatically rejected females over the age of 55 and males over the age of 60 in violation of the Age Discrimination in Employment Act. A consent decree was entered, which means the EEOC is going to be in their cornflakes for at least the next 3 to 5 years, monitoring it and making sure that they're not discriminating on the basis of age. They use software. iTutor was the employer. They used software to filter out their applications. It was software that they bought down at wherever, Office Max, Office whatever. They didn't create it. But then they said, well, we didn't create this software. The EEOC and the court basically said, you're using it, therefore you have to vet that equipment to make sure that it's not doing that sort of thing. That's the employer's responsibility. So if you're using that type of program that does human resources type work in filtering through or rating or organizing your applications, your performance issues, that sort of thing, you've got to vet the system that you're using, because it is not necessarily created in a country where they have to worry about discrimination laws. Job interviews, chat bots, resume scans, all of that can be done with AI. But again, if you're using that type of program, you are responsible for how that program functions. And if you remember Suits, when Katrina wants to fire Brian, that was a perfect example of, I did what Brian thought was going to take her 2 weeks. She did it in about 4 hours, and he didn't like the results because somebody he didn't want to fire was on her list to be terminated. So that's if you like Suits. Mobley versus Workday is another case. It's in the Northern District of California that's pending. Mr. Mobley is a black individual over the age of 40 with a disability. He sued Workday on the grounds that he was discriminated against based on those categories, and he has made headway against Workday, and they now have a class certification. So Workday is going to have to deal with a class action lawsuit because the algorithm in Workday's processes discriminates, is his allegation. He has made enough of a headway. He has made enough he hasn't won, but he has made enough credibility in his argument that the court out there has certified a class action. So we're watching that case, obviously. Guidance on harassment, I'm not going to spend a lot on that other than, because I want to talk about retaliation here. Anything you put in an email, you got to be careful about. I do want to talk a little bit about that. Emails, the E in email stands for exhibit. And I will say also beware of late afternoon frustration. And I would be remiss if we didn't talk about the Jumbotrons. As a fan of Coldplay, I'm not gonna criticize them, but it illustrates a point that I think is very significant to really everybody in the room, but certainly management, supervisors, your emails, your text messages, your footsteps. Everybody's Ansel Adams. Everybody is Ansel Adams. Everybody has a camera. You're always on. In this case, this was an actual case. I've used employee and employer because I don't want to embarrass the employer. It is an actual case, Middle District of Tennessee case. The employee asked to work remotely. She had situational anxiety over COVID, didn't we all? But she had something we don't all have. She had a doctor's note saying that it was a needed accommodation. The email trail, and I've looked at it, it's in federal court, it's an actual case, I can pull it up, and I read the complaint. I was like, oh my gosh. The email is only between upper level management, the CFO, the CEO, human resource director. I think there are like 4 or 5 people on the email trail back and forth about how much it was going to cost for the company to set her up at home. It was going to cost like $15,000 or $20,000 because they didn't have that, and so it was going to cost that. And obviously, it was irritating from an expense standpoint. Human resources were like, we don't really have a choice here. We need this person. And one of the upper level management individuals hit the reply all and said, let's accommodate her by firing her. Frustration, I get it. You know, we've all maybe thought it. You don't say it. Well, what happened was she was accommodated. They set her up at home, spent $15,000, $20,000 setting this person up at home, and 6 months later, her production was down, and they let her go. Complaint for retaliatory discharge. And that email is attached as Exhibit 1 to her complaint filed in federal court. She's not on the email. So when you look at the complaint and she says this is in, and the court relied on that email because the employer filed a motion to dismiss and the court said, not so fast. Have you read this email? And the court denied the motion to dismiss based on that. But when you look at that email, she's not on the email. So how'd she get it? Somebody gave it to her, somebody forwarded it to her, somebody left it sitting on their desk. Some way, somehow, she got it. And so when you send these emails, when you send these text messages, the text messages never go away. I don't care if you've changed your phone 15 times since that horrid text message, or if you've changed your carrier. I don't care. I've gotten text messages from 8 years ago from a carrier that the person no longer uses. And they were happy to send me text messages about that big. And the person's like, well, that's from a phone. I think I dropped that in the Indian Ocean. Well, they've still got your text messages. They don't care because it's on the cloud, remember? So be careful about those. Be careful. And that's another thing your supervisors really need to understand is when you hit those text messages and you use terms that you really don't want on the big screen, rethink that. Slow down, because that text message is going to go out there and it's going to be discoverable. You're always being watched. That picture is significant to me. Individual had a lawsuit, and the issue was not being tethered to the construction site. He had broken his back because he had fallen 20 feet because he hadn't been tethered. He was out for a year with a workers' comp claim. He came back to work. They returned him to work, and within 6 weeks, the supervisor of the construction site saw him standing close to the edge and not tethered down. They fired him. He sued and said, that's pretext. You're just mad at me about my workers' comp claim. And I represent him. The employer's like, oh, no, we enforce our safety rules, blah, blah, blah. that's not the picture, but a picture very similar to that of the person who made the decision to fire the guy standing that close to the edge and he wasn't tethered down. And needless to say, we settled that case. Pregnant Worker Fairness Act, you've heard about that law, I'm sure. You want to be very, very careful before you deny an accommodation request from a pregnant employee. And again, we're just kind of breezing through this. The point I want to get to here is that the EEOC is already filing lawsuits for violations against this. So if you have a pregnant employee who needs an accommodation, you want to treat it with kid gloves, because that you really slow down. And if you need, to talk with your attorney about that, if you need to talk with human resources, certainly supervisors need to be trained that this was, whether you like him or not, this was the fulfillment of a campaign promise by Joe Biden. Because Joe Biden, one of his campaign goals was to keep working women in the workforce. And if one of the typical responses to an employee who is pregnant and needs an accommodation is, can you take a leave of absence? Unpaid. Why don't you just take a leave of absence unpaid and come back when you're not pregnant anymore? And Joe Biden basically, I'm paraphrasing, but he basically said that's not good for the female. That puts her behind the 8 ball in the workforce, and then she has to, make up that, 9 weeks or however long she's out. And that's not the answer. The answer is an accommodation. Find something that the individual can do and continue to make money. So that, again, we're like not. That's fulfillment of a campaign promise. But look at what the EEOC is doing. They're filing discharge a pregnant employee because the employee requested accommodation to attend monthly medical appointments. So again, be very careful before you deny that claim. Personal liability on the Fair Labor Standards Act. There is a case that I want you to know about. It's the Spears versus Bay Inn. I would not recommend that you educate your employees about this, but employers need to realize that there is individual liability under the Fair Labor Standards Act and by extension the Family Medical Leave Act. That means that, for example, Sonny Patel was the manager, and the 11th Circuit Court of Appeals, which is Florida basically, had sufficient control over the operations of the hotel to be personally liable for the failure to pay the wages owed. He knew or should have known that the individual was not being paid correctly under the Fair Labor Standards Act. And Mr. Spears sued not only Bay Inn and Suites Foley LLC, his actual employer, but he also sued Sonny Patel, who was his manager, individually. And not to be too harsh, but what that means is how much money do you have in your savings account? I think Mr. Patel got a judgment against him for $135,000 for wages. So be aware of that. That's why if somebody complains about their wages, if somebody is being asked to work overtime and not put it down, if people are on FMLA, and the manager or the supervisor is continuing to call them and email them and text them and get them to work while they are supposed to be on leave, all of that is problematic. And it may be something that Human Resources doesn't realize is happening. But it creates an FLSA exposure for the managers as well as the employer. So all of that needs to be, as I say, employers need to have training programs for managers to ensure they understand their responsibilities and their potential exposure with respect to wage and hour laws. Policies, let's see. You want to train your supervisors and managers, update your policies. A 15-minute call with your favorite attorney can save some time, stay abreast of changes. We're going to take a little bit of a break and we'll come back and talk about, and I will get you out at 11, so maybe 5 minutes, 10-minute break.
That's good, yeah.
Okay.
Thank you.
You don't necessarily have laws that are specifically related to retaliation. It's an offshoot, basically, of a lot of other laws. It is a real danger because I don't worry. I partner with a lot of employers. We kind of are long-term relationships with a lot of clients. And I don't really worry about those clients. I don't worry about the individual human resources. I don't really worry about human resources, for the most part, messing up. But what I worry about is stuff that human resources doesn't know about. And retaliation is one of them, because a person can handle a ADA accommodation. We can handle an FMLA need. We can do those things. We can have a beautiful handbook. But if the supervisor out there in the trenches says something or does something or doesn't do something that the human resources folks don't know about, that can still create a retaliation claim. And it can come back months, years after the protected activity. And that does worry me, and that is why I think supervisory training is so important, to educate the supervisors on how they can handle something. I know that supervisors and managers are production oriented. They're not lawyers, they're not human resources people. They're production oriented, they're goal oriented. They've got production, they've got deadlines, they've got all of that stuff that we all enjoy. And they're trying to get it out the door. They're trying to make a customer happy. They're trying to keep things running. And when the lawyer comes in or the human resources comes in and says, well, we need you to do this or do that, that's not production in their view. And I get that. But I think it's imperative that the human resources management convey to at least some of the supervisors, and you have to kind of think about it from the standpoint of which managers, which supervisors, that sort of thing, conveys to them the significance of handling an employee after the fact, after the protected activity has taken place, and making sure that they don't do something that smacks of retaliation. Retaliation occurs when an employer takes adverse action because or as a result of engaging in protected activity. They are generally broad with attorney's fees, they're generally employee favorable, and a lot of these laws that we're talking about have provisions that say you can't retaliate based on an employee's use of the protections of these laws. Tennessee Human Rights Act, I'm not going to go through the steps, but basically, here's a good example that the prima facie case is that the employee engaged in activity protected by the law in question. The employer had knowledge of the protected activity. The defendant employer took employment action that the employee did not like. And there is a causal connection between the protected activity and the action that the employee did not like. And anything that the employee does not like, they can argue, oh, that's retaliatory. You didn't give me a big enough raise. Oh, that's retaliatory. Well, is there a causal connection? And you can say, oh, we gave you a 5% raise. Yeah, but you gave everybody else an 8% raise. Oh, we gave you a 5% raise. What do you complain about? You gave everybody else an 8% raise. The reason you cut me 3% is retaliation. It doesn't seem like, you kind of think, man, you got to be kidding. You got a raise, shut up. But to them, is there a causal connection? And even though it may look like, man, they gave them a 5% raise, or, that's not a good example, but my point is, they didn't do anything bad to you. It's gonna open up a can of worms, and what did you do to everybody else? Comparisons. Did you single this person out for some sort of not as nice decision? It can be adverse. Again, the plaintiff needs to establish that they are protected. Refusal to participate in or remain silent about illegal activities under the Tennessee Public Protection Act, that's a state law that has a retaliation provision. And all these laws are going to have these different bullet points that you have to prove. That the plaintiff has to prove that come into the defendant's, what did the defendant know, what did the employer know, and when did they know it, and did they use it as a basis for a decision. All of that is fact-driven, and so it's Tennessee common law is judge-made law as opposed to statutory law. And again, that's another, was a substantial factor in the employer's decision was the exercise of this employee's right. All of that is going to be mired down in factual inquiry of what was in the supervisor's head and heart when they made the recommendation that the employee only get 5%. Well, we gave Mary 5% raise because her supervisor, Sam, wrote it here that this is what he would recommend. Well, what was in Sam's head and what was in his heart? Is he still mad because I took FMLA leave? Who knows? Is he still mad because I reported a safety complaint that makes it harder for him to do his job? That was like 8 months ago. Yeah, is that a causal connection? What would a jury say? All of that goes into arguing about retaliation. It's not just discharge, it can be anything that they don't like. Protected activity, material adverse action, and a causal connection. And again, really what you deal with 9 times out of 10 is that causal connection issue. Because again, that gets into what was in somebody's head and what was in their heart, what was really motivating them. If the supervisor can say, the only reason you got 5% as opposed to 8% is because you messed up an order 6 weeks ago that cost the company $75,000. Oh, okay, I can see that. That's kind of an intervening issue between my FMLA and the issue of the raise. Generally, it's not that clear, though. So those are the elements. What's a protected activity? That can be very broad. What puts them into the category of being protected? Filing a complaint, really anything, opposing discriminatory. I'll give you an example. There's a Supreme Court case. I forget the name of it. It'll come to me probably when I finish here. There's a Supreme Court case, though, that holds that a complaint can be very broad, and that's what you need to realize. It's not a piece of paper. It's not a complaint in federal court. Guy was clocking in to his work, and he was standing in line, clocking in every day, and the supervisor was standing there watching him. This has been 10, 15 years ago, so times are different, I know, but run with me here. He would clock in, and when he would clock in, he would complain to the supervisor, the time clock is messed up. Time clock is messed up. Time clock is not right. You remember the case? Yeah. Time clock is messed up. Time clock's not working right. And it got all the way to the Supreme Court because the manager finally got tired of hearing it. So you keep crabbing about the time clock, you're fired. Well, what the employee alleged was, you fired me in retaliation for what? A wage and hour complaint. You never filed a complaint. You never called the DOL. You never you never went to Human Resources. No, but what you did was you stood in line and verbally articulated a complaint. And the Supreme Court of the United States says that's enough. Because it was
messed up.
Yeah.
It was.
I don't know whether it was or
Oh,
not.
okay.
I mean, it really wasn't. I mean, I understand.
It isn't the issue, but I do wonder.
He was complaining that it was cheating, not a time.
Yeah.
You know, and the supervisor basically was thumbing his nose at it and saying, "Just get to work."
Yeah.
You know, and I don't think they ever investigated whether the time clock was wrong. They fired the guy for, shut up, get to work. And the employer's defense was. I sure wish I could think of the name because it's been too long. But the employer's defense was, you didn't file a complaint, and that doesn't rise to the level of a complaint under the Fair Labor Standards Act, and the Supreme Court said, yeah, it does. So supervisors need, to his point, the gentleman in the blue shirt, that guy should have taken it to Human Resources. Hey, I don't know what to do. Do we need to get this time clock checked out? But the supervisor didn't do that, made a decision on his own. And I get it, because supervisors are production driven. They're great. They do their job and all that sort of thing. But they just need to realize the exposure that they can have when they make decisions without engaging in human resources. So potential adverse actions: termination, discipline, poor performance review, transfer to less favorable working conditions, change in pay, disciplinary action that's later, even if it's later rescinded. All of those are kind of case driven. Again, I'll look at actual cases that are filed. Lawrence versus Nashville Fire Department is a case from 2024. She filed a sex, age discrimination, and retaliation lawsuit. And interestingly, a 64-year-old African-American woman employed for 30 years. She had excellent performance, but she was subject to the good old boys club, and a younger, less experienced male colleague from another department was basically put in her position. And she objected to it, and she voiced her objections and alleged that that triggered retaliatory measures, unjust performance improvement plan, disciplinary action, suspension, drug testing, and so forth. EEOC, she went to the EEOC, they granted a right to sue, they contested the claim, but a national jury returned a verdict in favor of her, finding violations of Title VII and the age discrimination. They found that the employer did not retaliate against her, but you still have, what I look at is what triggered the lawsuit really was the retaliation. And a lot of times that's what happens, is there may be some hint of, well, was that really fair what you did? But then when you retaliate, when there's something where they just feel personally offended, that's when they go get the attorney or go to the EEOC. And Paul and I were talking about it before we got started, and I think one thing that in August, I can't believe we're in August, anyway, and here we are in August 2025, and one of the things that I think we're all kind of dealing with is uncertainty. I was listening to NPR as I was coming across the highway there, and they were talking about the uncertainty in the economy and how, oh, this has just happened. I'm like, where have you been? Uncertainty has been a while, but employees are dealing with that. And so when you sit down with an employee nowadays with discipline or adversity or anything negative, what I'm hearing, what I'm getting the sense of from a lot of my clients is employees are fearful. They're nervous. They're nervous about their job. They're nervous about the cost of things. And there's a lot, NPR is right, there always is uncertainty, but I think they are accurate that there is some uncertainty. The Wall Street Journal had an article about a week ago about how nobody's really moving. Nobody's really buying houses. Nobody's really changing jobs. They're scared. There's an uncertainty out there. And so I don't know if that's necessarily true. That's beyond my pay grade to opine about that sort of thing. But there you are in NPR and the Wall Street Journal, two different points of view. Noting, so when you sit down with your employee and you give them bad news, just be aware, I'm not saying that you're going to change the bad news because that's a business decision, but just be aware you're sometimes dealing with somebody who's scared. And what do scared people do? They run for cover, and sometimes they run for cover to the EEOC or to a plaintiff's attorney. Because they're advertising on TV every night, right? That I'm going to call this attorney. So just keep that in mind right now. That it's not like it was 5 years ago where people can just go work in Indiana or work remotely. Things are different, and I think people are feeling it. That's a bad day where you get a verdict in federal court for $225,000 and back pay and $45,000. That's a bad day. Fast forward to May of 2025, a Memphis, Tennessee employer. An employee was the chief people officer, and she was also an attorney with the law firm, but she was the chief people officer. And she sued her employer alleging retaliation under Title VII, Fair Labor Standards Act, and the Equal Pay Act. She brought a pay disparity issue to the attention of her boss, who was the owner of this law firm. Subsequently, she was demoted and terminated. Her concern, her pay disparity, was she determined as the chief people officer that an incoming male attorney was going to be paid more than female attorneys who were already at the firm with more experience. So she, as chief people officer, she went to the owner and said, hey, you need to realize it. It doesn't look good. It's probably a violation of Title VII, Fair Labor Standards Act, Equal Pay Act. And her owner didn't like that. So her boss basically said, your history, you're fired. And so you can barely read that, I know, but I'll walk you through it. The jury said, and this is a verdict form, and if you ever have the pleasure of being in federal court, the lawyers will spend probably 2 days working on the verdict form. Because it's very important how you present those questions to the jury is very critical. We find, the jury said, we find by a preponderance of the evidence that the defendant employer retaliated against the plaintiff in violation of Title VII. Yes, that's a bad day. We find by preponderance of the evidence that they retaliated against the plaintiff in violation of the Fair Labor Standards Act. Yes, that's not good. And they went on and said you violated the Equal Pay Act. Yes, if you answered yes to any of the 3 questions, go to page 2. And so they went to page 2. This is where you don't want to be. We find that is entitled to back pay. If you answered yes, enter the appropriate amount of back pay, $258,000. You suffered compensatory damages. Yes. That's a yes jury, aren't they? If you answered yes, enter the amount of compensatory damages, $516,000. If you find that they're entitled to punitive damages, yes, $2.5 million. That's a Memphis jury on May the 7th of this year. That is a terrible day. The last one was a bad day. That's a terrible day. Bad facts, but that's where you don't want to be. And so that case is illustrative to me because you've got 3 retaliation claims. You've got the Equal Pay Act, the Fair Labor Standards Act, and Title VII, all of which have retaliation provisions. Every single one of them, yes, yes, yes. So this was an owner, but supervisors need to understand complaining, making allegations, saying you're not treating me fairly, all of that, there kind of needs to be a stop there. And get that to human resources, get that to the people who can handle it and handle it in-house so that you don't wind up like that. Tosh Pork was another one. That was one, just really quickly, he complained about wages, and it was a retaliation case as well. And that case is actually still pending. So that was that. The thing that's interesting about that case is Tosh Pork was sued by the Department of Labor. So a lot of times if it's a wage and hour dispute, they will go to the Department of Labor, and the Department of Labor can file a lawsuit based on Fair Labor Standards Act violations. The other thing that is worth noting about the complaint that you're looking at there from the Western District of Tennessee, you look at the defendants listed. So the Department of Labor sued Tosh Pork LLC, and who is this Diana Rosa? That's the Human Resources Manager. Like I say, you got individual liability exposure under the Fair Labor Standards Act. And so that's your friendly Department of Labor. Usually the Department of Labor doesn't go too hard against an individual, but in this one there are bad facts, and so they may very well. Again, it's still pending, I believe. Yeah.
Okay, so This is under the federal
Yes.
laws, but is there personal liability risk for state wage and hour violations? Like not giving meal breaks
Not unless you dragged in the federal law.
or, okay.
I mean, most plaintiffs' attorneys, if I were a plaintiff's attorney, and I'm not, but if I were, I would drag in the federal law because of the attorney's fees. Because under the state wage and hour people are pretty good to work with. I mean, you know, we had Carol Merchant for a number of years from the state. She was federal, but she worked with the state people too. And the state people are a little bit less aggressive about some of those things. In Tennessee, just Tennessee, state, North Carolina, Virginia, I'm not talking about them because I don't know them. But generally speaking, if an attorney feels like there's a state violation, they're going to bring in a federal court violation for the attorney's fees and the liquidated damages, because you just get more damages under the federal part of it. But no, the state law doesn't have, it's not as aggressive with some of those damages claims. Supreme Court, I talked a little bit about the Groff decision. That was part of a retaliation case, but there's also this one, religious accommodation, and on the heels of the Groff decision that I talked about earlier, where the standard has been lowered for proving an accommodation necessity, there's this case that was filed in June of this year by the EEOC against a company out in Nevada alleging retaliation by a group of individuals after they opposed some religious discrimination and participating in a protected activity. And the settlement is for $850,000 to be distributed against the individual. I can't remember how many individuals are in the class, but then they've got that 3-year consent decree. So again, you know, people say, you know, we're in a kinder, gentler country as far as employment discrimination and aggression, and you're really not, because you've still got the individuals with the EEOC who are filing these lawsuits, whether it's a Pregnant Worker Fairness Act or the religious discrimination, retaliation, that sort of thing. So just something to be mindful of. If you are a publicly traded company, you've also got Sarbanes-Oxley to consider. This was one that where Murray sued based on alleged whistleblower protections. The jury found he had established his claim, and you know, the retaliatory intent. They go through all this with respect to the Sarbanes-Oxley, which can get pretty complicated. But later on, in a case that is very similar, Zornoza versus Terraform, a case that's been going on for, you know, since November of 2015, they finally settled that case for $35.5 million. And that was a publicly traded company whistleblower retaliation lawsuit under Sarbanes-Oxley. So if you are a publicly traded company, you also have that part of the law to be concerned about with whistleblower retaliation. Let's see. Another Supreme Court case in Muldrow, you'll hear about it. Here, the Supreme Court held that an employee alleging discrimination, retaliation, that sort of thing, must show some harm, but doesn't need to show significant, serious, substantial, or that it exceeded any other heightened bar in order to establish sufficient harm to have a case. So Muldrow, bottom line is, it makes it easier for employees to establish that they have had some harm through an adverse action and establish a claim. So just be aware, again, that was a 2024 case. National Labor Relations Act, I always mention this because it applies whether you have a union or not. A lot of employers say, well, I don't have to worry about the NLRA because I don't have a union. It doesn't matter. If you have a union, yes, you do have to worry about it, but even if you don't have a union, You cannot fire, demote, or transfer employees for expressing pro-union ideas. You can't reduce pay or retaliate, basically, for engaging in protected activity, which can include asking about wages, asking about hours, benefits, that sort of thing. Anything that where they engage in pro-union activity. We need a union around here. You've got to be very careful that you don't do anything that is going to be interpreted as chilling their effort to engage a union. So you have to be careful about that, whether you have a union or not. You want to have a written policy. That's one thing that I think is very essential nowadays. And nowadays that cannot be, or it can be, it should not just be a blurb in your harassment policy. An anti-retaliation policy should be a freestanding, separate policy in your handbook. It does not need to go, it doesn't need to be a roadmap to help people file a claim, but it does need to be something that if you feel like you've been retaliated against, if you feel like you're being treated unfairly, again, you want to get them in your door rather than have them call a plaintiff's attorney. And I often suggest to employers and HR folks or a supervisor, manager, if I do supervisory training, I tell the supervisors, you don't wake up one day and say, oh, I want to deal with a harassment claim. Nobody wants to do that because you've got production, you've got a line of things to do, you've got a to-do list, and this person complaining to you is not on your to-do list. However, if they come to you and say, hey, I have a problem, I have a gripe, I have a complaint, I need thus and so, I need to talk to you about something, we'll sit down, oh, it's, Johnny's harassing me, or I need to take some time off, or I need thus and so. It may not be something that you can handle right then. The supervisor may not be able to handle it right then. Tell the employee that. Say, hey, I can't handle this right now, I've got a deadline, and I'm trying to get this out, but let's schedule a time when you and I can go to Human Resources and talk about that. Or let's go to Human Resources right now and talk about that. The other thing that I like to suggest to supervisors or managers is if you're caught off guard by the fact that this person knocks on your door and says, I got a complaint. Johnny's harassing me. I'm tired of dealing with Johnny. He's yelling. Calm the person down. Say, hey, take a seat. Thank you. Thank you for coming in. I appreciate you coming in. Two things that does. It tells the person that you appreciate them coming in. And you really should appreciate them coming in because they're not calling the EEOC. That's their alternative. That's their scary alternative. Plaintiff's attorney, EEOC, Department of Labor. That's what you don't want. So, it's a little bit like if your child comes to you and says, hey, Mom, I got a problem. Hey, Dad, I got a problem. Thank you for coming to me. And that should be the first thing. It's just that sensitivity. That's the one thing it does. It makes you look good. But the first thing I say to them is thank you. The second thing it does is it helps you figure out what you're going to say next. It gives you a little bit of time. Because do I have time to deal with this? Am I prepared to deal? Do I know what I'm doing? Am I comfortable dealing with this? Do I need to get it to Human Resources? How do I do this? And you think about that. And I think that's something that if you do the supervisory training, that's kind of something that I would encourage you to sort of talk about with your supervisors is, hey, nobody comes to work thinking that you're going to deal with a discrimination complaint. But if it's brought to you, have a little bit of a sense of how you're going to deal with it. Even if it's something that you have on a pull-out drawer that says, okay, this is how I deal with it. Thank you. Okay, thank you. At least have something so that you can have a cheat sheet of how to deal with it. And we need to get Human Resources. I don't want to get Human Resources involved. This is just between you and me. I don't want to start a complaint. You need to be prepared. You need to help your supervisors be prepared for what do I do when somebody says, this is just between you and me. I really don't want human resources involved. I don't want to get Johnny in trouble, but I can't stand him. Can you fire him? You know, you got it. Supervisors don't come into work knowing how to handle that. And so I think it's important in your training and certainly with the policies, you want to make sure your employees know the policies. You want it to be user-friendly. You want to have reporting processes. You want to have more than one person that they can report it to. But the thing is, I've seen handbook provisions that have, 8 or 10 people that you can report it to. Well, are all those 8 or 10 people prepared to handle it? Are you sure that they understand really how to handle that type of a complaint? Or is it going to be like this person does it this way and this person does it that way and there's no consistency? So you have to, and every company is different in terms of how many people you list out there, or how many, how many managers, how many positions you list out there. The EEOC effective training. The reason they have rescinded part of their regulation that deals with some aspects of diversity. They have not rescinded that part. And I will tell you, increasingly the EEOC is asking for proof of your training. And one of the things I've had an EEOC, a very aggressive EEOC investigator ask me is, send me your training. Send me the employer's anti-harassment training. Here's their policy. That's not what I'm asking for. I'm asking for your training. Well, it's a video. Download it, send it to me. And we had to do that. And the Sixth Circuit Court of Appeals has said there are cases that say you can have a Monet or a Van Gogh, to use a local exhibit, you can have a Van Gogh of a policy. But if you don't have effective training, your policy is not an effective harassment program. Training is an essential component, and it needs to be periodic and it needs to be effective. It should be something that you could print off or download or prove. Because even if you're not dealing with the EEOC, you may be dealing with a federal court where you want to prove to your jury, this is what our program is. Look at this program that we have every year. This is our program, so that you can prove it. You need to, again, this is the EEOC saying that you need to explain your policy and complaint process, alternative dispute resolution, confidentiality. You want to provide examples of prohibited conduct. You need to do that carefully. As the Wicked Witch of the West says, these things must be done delicately. And so you don't want it to be a roadmap. You want providing supervisors and managers about how to prevent, identify, stop, report, correct it, with clear instructions for addressing and reporting harassment or discrimination that they observe. If a supervisor sees it, the company sees it. I've dealt with that over and over and over, and I get passionate about it because it puts the company at risk. If the manager sees it and doesn't do anything about it, they don't need to be a supervisor. If they see harassment, if they see something that is wrong, if they see something they think, well, she looks like Johnny's harassing her, but that's not my employee. Well, yeah, Mary came and complained to me about it, but I told her she needed to talk to her supervisor. Are you a supervisor? Are you not? Yeah, but I don't supervise her. It's that brick on your shoulder. And that's what supervisors need to understand. I dealt with with the EEOC and a consent decree against the company. Nobody around here. It was not even in Tennessee. But the problem was the supervisors had seen it. The supervisors had seen the problem over and over, but they never reported it up the chain because the person was not in their what? In their line of supervision. And the EEOC absolutely nailed the employer. That was before we got involved, but we got involved later when we had to deal with the consent decree. And so they are serious about this. I give you this because it is not. This is what the EEOC is going to look for. It's tailored to the workplace and the workforce. It's provided on a regular basis in a clear, easy to understand style and format. Supervisors need to be able to recognize a report or a complaint of retaliation. It can be vague, but the company's responsibilities begin when the supervisor, manager, or human resources knows of the complaint. Emails and texts are perfect evidence. It doesn't matter if you're related to the complaint. It doesn't matter if you're off the clock. It doesn't matter if you're in the direct line of supervision. If you hear or see something, or if you get a complaint, the supervisors need to report it. And again, the easy answer there, the easy button for a supervisor or a manager is get it to human resources. That's what I want the manager, when they're sitting in the witness box, when they're sitting in a deposition and I'm defending them, I want their answer to be when the plaintiff's attorney says, and Mr. So-and-so, what did you do when Mary complained about discrimination? I want their answer to be, I went to human resources. Because I knew that's who could handle it. And then human resources is going to handle it. That's your safety answer. As opposed to, well, I told her to go home, or well, I told her. No, I told her to go to human resources, and then I went to human resources too. Don't just tell Mary to go to human resources. I told her to go to human resources. Did she go? I don't know. I went to human resources too. And I know if you're production, it's like, oh, God, maybe I worked third shift. Okay, shoot human resources an email. I need to talk to you. Don't put it all in, don't bleed all over the email with this information, because that's what discoverable. But I need to talk to you. So all of that is a component of your training. I've talked to you about emails. It's going to kill us. I already talked about that. So you want to train your supervisors and managers. You want to educate your employees on your policies. Two different methods of training. You don't want to educate your employees on the same thing that you tell your supervisors. But you want to make sure they know about your policies, where to find the information, how to report it, who to report it to. They want to know that you care. Employees want to know that you care. And they want to know that you care if they have a complaint. And that you will address it and handle it. And your supervisors want to know that too, because the company has, if we don't have supervisors and managers that are willing to do their job, it's going to make all of our jobs a lot harder. And so we want supervisors and managers to be able to do the job for which they were hired, which is not necessarily human resources, but they are in the trenches. They're the ones who may very well see the problem or get the complaint or get like in the Yannick v. Kroger case, I'm struggling with my full time. That was laid in her lap, and she should have gotten it to human resources. So you want to stay abreast of changes. If you want if you want the PowerPoint, do shoot me an email. If it'll go. There. There's my email address, and I'm happy to send it to you. And I'm sorry I'm 7 minutes over time. Sorry.
We'll let you go.
All right. Thank you.